Well, good evening, everyone, and welcome. Thank you for joining us for tonight's discussion on an incredibly important set of topics. My name is Anjali Parran, and I'm the Assistant Clinical Professor of Law at the University of Chicago and the Director of the Global Human Rights Clinic. We'd like to remind everyone that tonight's program is on the record and that any views expressed by the speakers here are their own and don't reflect any institutional positions, including that of the Council. We'll start off with a general conversation with our panelists before then having some time for a Q&A with you all. And so before we begin, I'd like to introduce our panelists, who are some of the most respected experts in the field, and we're tremendously lucky to be able to have them. So Leila Sadat is the James Carr Professor of International Criminal Law at the Washington University Law School. From 2012 to 2023, she served as the Special Advisor on Crimes Against Humanity to two International Criminal Court prosecutors. She's the Director of the Crimes Against Humanity Initiative and the Gun Violence and Human Rights Initiative. She also serves as Chair of the International Law Association American Branch and is a member of the U.S. Council on Foreign Relations and the American Law Institute. She's currently a fellow at Yale Law School's Shell Center for International Human Rights. And David Sheffer is currently a senior fellow at the Council on Foreign Relations and professor of practice at Arizona State University. He's also director emeritus of the Center for International Human Rights at Northwestern Pritzker School of Law. He served as the first U.S. ambassador at large for war crimes issues during the Clinton administration, where he led the U.S. delegation in the establishment of the International Criminal Courts and signed the Rome Statute on behalf of the U.S. in 2000. He's also played a crucial role in negotiating 5 war crimes tribunals, including those of the former Yugoslavia and of Rwanda. And so I think we couldn't have really better people to talk about some of the issues that we face today. And today's discussion is hopefully going to be really wide-ranging, focusing on the two situations that are at the front page of the news at the moment, that of Israel and Palestine and the situation in Ukraine, but also on global justice issues more generally and the myriad of other conflicts that are receiving less attention in the news. But maybe just to start off, David, with the basics. What distinguishes international crimes from kind of ordinary, everyday violence? And can you tell us a little bit about the evolution of international criminal law as a field?
Well, as a field, international criminal law is mostly a creature of post-World War II. It reaches a little bit earlier than that, but since the Nuremberg and Tokyo tribunals, we really have seen the establishment of this body of law, which took sort of a hiatus during the Cold War, and then for the last 30 years, it has had an enormous projection and momentum. Why? Because, first of all, we have the underlying statutory conventions that help comprise part of this law, including the Genocide Convention, the Geneva Conventions, the Torture Convention. Those are massive codifying instruments after World War II that established the base for this. And then when we negotiated the Rome Statute of the International Criminal Court, we tried to take that a step further and modernize it so that a court could essentially go after leaders who participate in criminal conduct that is either genocide, crimes against humanity, war crimes, or aggression. And I think the distinction, very simply, if I may put it, between international criminal law and what you all know as criminal law in your everyday life here in America is that international criminal law goes after the mega crimes of our society, the crimes that are simply, as we say in the law, jus cogens crimes. They have no basis for legality. You cannot enter into a treaty that, for example, says we're going to commit genocide. We have the agreement that we'll do that. Or we're going to enter into a treaty and say we're going to commit war crimes with you, our treaty partner. Isn't that okay? No, that's actually not okay under international criminal law. But it is essentially using law at a very high level, a leadership level, not going after all of the foot soldiers, all of those who wield the machetes during the Rwanda genocide. That's not where international law is administered. It's really administered at a leadership level. And so that would be the basic distinction between those two fields of law. And then if you want, we can just briefly describe the distinctions between the laws, but
Yeah, I think it would be, helpful because, we're seeing a lot in the news kind of talk of potential war crimes, crimes against humanity, new discussion about whether, genocide is useful as a term, and maybe to either of you or Leila, kind of, is it possible to explain a little bit the distinction between the various crimes within international law?
do you want to do that?
Yeah. So, good evening, everybody.
We co-teach,
We
essentially.
co-teach, exactly. Good evening, and thank you so much for having me. So, when we think of the three core crimes, these three mass crimes, crimes against humanity, genocide, and war crimes, for war crimes, you have to have a war. That's the most basic thing. And we have codifications of the laws and customs of war that go back centuries, actually. Some of them were written down into the Hague Treaties of 1907 or 1899, the Geneva Conventions of 1949. We have rules relating to what weapons are legal in war, and then we have rules relating to the conduct of hostilities, what kinds of things you can do during the war. Crimes against humanity is a larger category of crimes protecting civilian populations in wartime and in peacetime. So unlike war crimes, you don't have to have an armed conflict to have a crime against humanity, although you often do. It arose in Nuremberg as a concept, and there was a war in that case, but there isn't always a war. So at the ICC, about 30% of our situations are actually peacetime crimes against humanity. The Philippines, Venezuela, Kenya, many situations don't involve armed conflict. Genocide is sometimes referred to as the crime of crimes, although that hierarchy isn't formal. It's more an informal sense of the crime. And genocide, unlike crimes against humanity, is about trying to kill off groups as groups. And the Genocide Convention, which was redacted in 1948, covers 4 groups. It omits many groups. And so that's a big gap in the law. It covers only racial, religious, national, and ethnic groups. And in order to show a genocide, you have to show that an individual acted with the specific intent to destroy in whole or in part that specific group. It can also have non-criminal responsibility, but I think we'll get to that. So that essentially are the 3 crimes. And then aggression is the 4th crime. Maybe we'll come back to the crime of aggression. And that's unlawfully, essentially, invading your neighbor, committing an act of war against a peace-loving state. And that's come to the fore in the Russia-Ukraine situation.
And so, I'd like to move to talk about Russia and Ukraine as well as what's happening in Israel and Gaza at the moment. But just before we get to that, historically, a lot of the tribunals that you would have been involved in setting up, David, the justice mechanisms tended to happen after the cessation of hostilities. So, for example, Nuremberg or Tokyo or the former Yugoslavia and Rwanda, which you were involved in. But what we're seeing now is that enormous conflict is unfolding in Israel and Gaza and Ukraine and Sudan, other parts of the world. And there is a big push to ensuring that there's kind of international justice for what's happening in that moment. I guess what is already happening and what should be happening to advance international justice in times of conflict when it's actually happening in that moment?
Well, actually, although the Rwanda Tribunal was established within about 6 months after the end of the genocide, which ended in June of 1994, the Rwanda Tribunal was formally established by November, December of 1994 by the Security Council. So it was an ex post facto concept, the tribunal. But the Yugoslav Tribunal was actually created in the midst of extreme violence in the former Yugoslavia that would continue for years after the establishment of the tribunal. The tribunal was established in the spring of 1993, very much under the leadership of my boss, Madeleine Albright, at the Security Council. And the war continued until late 1995, and one of the worst acts of the war, the Srebrenica genocide, occurred in July of 1995, several months before the Dayton Peace Accords of December 1995. So we actually experienced a tribunal in real time And one of our arguments at the time, probably too idealistic, but it was an argument, was that by establishing it right in the middle of the war, we hope to be a messenger of deterrence to the leaders in that war, that they not commit war crimes or crimes against humanity or genocide in the conduct of the war, and that hopefully it would help lead ultimately to some resolution of the conflict, or at least be part of that. It also spurred the International Criminal Court in the sense that when we were negotiating the ICC in the 1990s, and those negotiations concluded for the main body of the statute in summer of 1998, that was very much intended to be a court not only to deal with past conflicts, but also to stand there ready to be activated right in the middle of armed conflict. And in fact, that has been the case. It has been activated right in the middle of, for example, the Ukraine-Russia conflict. So the objective was actually to create a legal system that was established and ready to act right in the middle of conflict. Now, there will be many who can research that and sort of academically analyze, well, does it at the end of the day make better sense to have the judicial mechanism after the end of the conflict, because you want to negotiate the end of the war, and then go to justice and accountability? And that'll be an ongoing debate. But here in the United States, we have criminal courts that don't wait until the conclusion of all crime in the United States before investigating and prosecuting crime. So criminal law should be a live part of the international system at all times, and not only after the conclusion of the criminal activity.
And so, I think that I hear you, and it sort of makes a lot of sense. Leila, kind of as an advisor to the ICC, I guess, what are the challenges of actually in practice doing that in the midst of kind of ongoing armed conflict, in terms of collecting evidence, building up the chain of command? As you kind of noted in your response to the first question, these are sort of crimes of an extraordinary nature, and often against those most responsible. They're not ordinary crimes where you're trying to go after every single person who committed them, but you're actually trying to go after the leaders, those who may have ordered and engineered the attacks.
So, Anjali, this is one of the biggest challenges, obviously, at the ICC. So if we take a case like the Myanmar case, Myanmar is an interesting situation for the court because we actually have jurisdiction because Bangladesh is a state party. Myanmar is not a state party. But what happened in that case is the attacks on the Rohingya people in Myanmar drove them through mass deportation and ethnic cleansing into Bangladesh. And so that's the jurisdictional nexus. So the first thing the court had to do was figure out, can we investigate it all? So how are we trying to investigate? Obviously, the individuals living in Myanmar, who we presume were responsible for the crimes that happened, we can't send investigators there because they would refuse visas to the ICC. They haven't joined the court. They have no duty of cooperation. What the ICC can do is take testimony in Bangladesh amongst survivors and victims. They can use satellite photography. They can use other evidence. But it is definitely a challenge to get what we call that linkage evidence between the commander and what happened on the ground. The way they did it in the Yugoslavia tribunal is really the United States was very generous in offering its intelligence assessments. And if you read the cases that were particularly regarding the massacre of Srebrenica, which the ICTY found to have been a genocide, they actually had the cell phone intercepts between the commanders. And so they had as evidence electronically transmitted transmitted evidence of this is what I want you to do, this is where I want you to do it, this is how I want you to do it. That's the kind of evidence you would really need to be able to connect. Now, one of the things that did happen in Myanmar is they were using Facebook and social media to actually promote ethnic hatred. So it may not be as difficult as we think, because often people in power don't ever expect to find themselves before an international criminal court, and they say things they probably shouldn't say in the public sphere or on Facebook or who knows elsewhere. And we can actually track, find, and gather that information. And the ICC has a new digital technology platform that is allowing it to do that much more effectively, because you also get some junk when you're looking at electronic or video evidence or social media. But it is sometimes easier than one would think, because people in power are often very careless about what they say.
Yeah, that's fascinating. And I think, of course, the advent of new technologies, of social media, while also bringing their own sets of challenges, especially in the context of Ukraine and Russia, we're seeing huge amounts of misinformation, the manipulation of photo, of video evidence, can be a really powerful tool to hold those to account. So I'd like to turn and talk a little bit about the situation in Ukraine first. And so there's a number of ongoing investigations. For example, I recently checked the Ukrainian Prosecutor General's office. They've claimed that they've now registered over 92,000 war crimes. And so you see this enormous collection of evidence. The International Criminal Court has opened up investigations and issued arrest warrants. Can you talk through, maybe David, some of the existing mechanisms and also what else you think needs to be done in this current moment?
Well, yes, I must say that with Ukraine, never before in the history of humankind has atrocity crimes been investigated as quickly, as comprehensively, as intensively as we see being undertaken with respect to the Ukraine-Russia conflict. And I say that because in the 1990s, we could not possibly be on the immediate time frame that has erupted over Ukraine-Russia. We were over a multi-year period of gathering evidence, finally bringing it to trial at the Yugoslav Tribunal. And even the investigations lasted long into the late 1990s, early 2000s in terms of uncovering mass graves, interviewing witnesses, etc. Here in the Ukraine-Russia conflict, it's like warp speed. There's an enormous international effort, and the United States is part of a tripart group with the United Kingdom and the European Union called the Atrocity Crimes Accountability or Advisory Group. And that means the United States, with the Department of Justice very much at the forefront of this, participating intensively on the ground in Ukraine in investigative work, forensic work, etc. But there are many other organizations, European organizations, European country organizations, civil society organizations are flooding into Ukraine in a sense. So I think that's encouraging. It hasn't stopped the fighting or anything. It hasn't deterred Russia, which is sort of just ignoring the fact that all of this is taking place. But international criminal law is a very long arc. You have to think in terms of decades. I would say 15, 20 years from now or so, there will be a much more substantial reckoning with respect to what's going on in Ukraine than what you're going to find in the next year, 2, 3 years. It's going to take a long period of time, and that's particularly true, if I might add, for the thousands of cases that the Prosecutor General in Ukraine has identified. You said more than 92,000. That will take decades to work through. This will be an ongoing process in Ukraine of investigating and finally bringing what are essentially foot soldiers. Now, remember, many of them are in Russia and you can't get to them anymore, but that's another discussion. The point is these crimes will be investigated, and under Ukrainian law, they can do so in absentia in terms of prosecuting these individuals. So there's a huge and long process underway, but I would say the good news is very intensive, very thorough. The bad news is it's continuing. It's a continuous assault on Ukraine, paired with atrocity crimes every single day, targeting civilian populations. And so that's the bad news so far.
And I think to your point, the ICC has issued arrest warrants extremely quickly by ICC standards. And so in 2023, for Vladimir Putin, and I guess what's the value of that? And to your point, if the conflict is continuing, violence is ongoing, if it doesn't seem to be slowing, if anything, it might be increasing. What's the value of issuing an arrest warrant in the middle of a war?
Well, can I answer this one first?
Yeah.
And then I'm going to kick it over to you. This is a very good question, but I want to just put down a cautionary point of view. It's too often the presumption that the International Criminal Court or a criminal tribunal of some character is going to actually bring peace, that it will be the peacemaker. It will be the solution to the problem. No, it will not be the solution to the problem. Its goal is justice and accountability. Just like in our domestic system, the criminal courts don't have the responsibility for law enforcement on the streets. That's somewhere else in our system. They have the responsibility for achieving justice, and we give them the latitude to do that. We don't expect more than that from our justice system in the United States. More or less the same at the international level. We want these courts to ultimately be seen as deterrents, as having the power of deterrence, but that's an ideal to achieve someday. In the meantime, just let them do the work that they're built to do, which is investigate and prosecute crimes that have already occurred, and do not impose upon these courts the responsibility to actually end the war that they are investigating crimes occurring under.
That's a great point, actually. Thank you for making that. I might have a couple of different thoughts. One is we know that Putin has already changed his behavior, right? He didn't go to the BRICS meeting right when the arrest warrant came out. So we've seen him start to change his behavior. The other point is everything that David said is true. And we also don't have a counterfactual. We don't know what a world would look like in which there was no ICC and there was no arrest warrant. What would Putin be likely to do? And my guess is, honestly, we are actually seeing, at least around the edges, some moderation and some change in behavior. I can't prove that. We can see it in some other conflicts. In the Uganda situation, for example, there was a huge hue and cry when the ICC issued arrest warrants for the members of the Lord's Resistance Army. Everybody said it's going to destroy the peace. Joseph Kony was about to come out and negotiate peace. And in fact, the ICC arrest warrants didn't destroy the peace, and northern Uganda is pretty peaceful right now. So in smaller situations with individuals who are maybe more likely to respond to ICC arrest warrants or be afraid of the ICC, I think we're seeing a much bigger impact than with a superpower, right? Russia is a superpower. So of course, President Putin is sitting in Moscow or wherever saying, they're never going to be able to touch me. But in the back of their minds, they know that the ICC has a pretty long reach. The United States just indicted 4 Russians for war crimes in Ukraine. So it's not just the Ukrainians going to bring the prosecutions. It's going to be all over Europe. It's going to be the United States of America. These prosecutions will reach long and far. And so it's true, you haven't taken down the sort of beast of impunity with one spear shot. It's sort of like the Lilliputians tying down Gulliver, but I think we are seeing effects. We just wish it would be faster and more direct, I think.
And I think to that end, one of the things that has come out of the conflict in Ukraine is a renewed attention to the crime of aggression, which, was included as a crime within the Rome Statute, not, it wasn't actually applicable, was sort of thought about, in Kampala a few years before Ukraine. But really with the advent of the war in Ukraine, people started saying, hold on, we need to talk about the actual underlying crime rather than these really serious international crimes that are more focused on conduct and intent and how you engage in hostilities rather than the actual fact that you invaded a country in the first place. And so, maybe first, is it possible to kind of explain a little bit about what is the crime of aggression and how is this playing out in the context of the conflict in Ukraine?
Right. Well, I'll just start by saying that easiest way to think about the crime of aggression is just think September 1939, Poland, Nazi blitzkrieg onto Polish territory. That's classic aggression. As it began to be formulated and defined both at the United Nations in a General Assembly resolution of 1974, and then in the Rome Statute negotiations, not only, sorry about that, not only at Rome, but also many years later, 2010 in Kampala, Uganda, when the crime of aggression was further established within the Rome Statute and activated. The crime basically is keyed off of the UN Charter, which is that it's the use of armed force against the sovereignty, political independence, territorial integrity of a member state of the United Nations, and everyone is a member of the United Nations. Now, there's a distinction between what is an act of aggression, which is how do you actually do this militarily? How do you invade the political independence and sovereignty and territorial integrity of a state? But then there's the crime of aggression. And it has been established now, particularly in the Rome Statute, but also drawing from Nuremberg and Tokyo, where aggression was the major crime as those tribunals got underway with their work, is a focus strictly on leadership. You don't try to charge the common soldier with the crime of aggression. He or she is just following the orders of the leaders to actually invade another country. It's the leaders that make those decisions. And so in our structure of law, what we're focusing on is exclusively the leadership with respect to the crime of aggression. And that's what in part makes it so very, very difficult, because you have to gather the evidence that will be suitable under criminal law standards to actually prove the guilt of a leader making those decisions. Are there documents? Are there witnesses? Are there public statements? In the case, I must say, of Vladimir Putin of Russia, there's a lot out there to put on the table regarding his identification with the crime of aggression, as well as some of his colleagues in the Kremlin. So that's going to be clearly available. But for the International Criminal Court, they will not be investigating the crime of aggression against Putin because of a jurisdictional issue. There's got to be found another way to actually prosecute Putin and his colleagues for the crime of aggression. Did you want to add to that, Leila?
That was perfect.
So I'd like to actually now turn a little bit to talk about Israel and what's happening in Israel and Gaza at the moment. So tomorrow hearings will start for a case that's been filed by South Africa against Israel, requesting for provisional measures and arguing that Israel's conduct in Gaza is violating its obligations under the Geneva Convention. And this is a case that will go before the International Court of Justice that hears disputes between states and also makes advisory opinions. So can you tell us a little bit about this case and really what's at stake tomorrow and with the ICJ's provisional measures hearing?
Should I start with that one? So this is not the first use of the Genocide Convention before the ICJ. The Genocide Convention was written in 1948, and it basically codified what happened in the Holocaust, if you look at the acts that are criminal in it. And there's a provision in the treaty, Article 9, that allows the International Court of Justice, which is the world court, this is the UN court, not the ICC, not the criminal court, that can hear disputes between states if an issue arises pertaining to the interpretation or the application of the Genocide Convention. Now, the Genocide Convention was adopted in a great fanfare and then sat on the shelf. It sat on the shelf for 50 years in the criminal sense, never used, and it sat on the shelf at the United Nations. And we got the first, I would say, significant use in Bosnia versus Serbia, which is, I want to say 2006, where Bosnia sued Serbia, and the court didn't find that Serbia had committed genocide, but had failed to prevent genocide, because the Genocide Convention also has an obligation of prevention. And then during, I mentioned the Rohingya, the Gambia brought a case against Myanmar alleging genocide. And 2 years ago, Ukraine brought a case under the Genocide Convention against Russia. And in the most recent cases, the World Court in the Gambia case and in the Ukraine case in particular had issued something called provisional measures. And those provisional measures, which are not an adjudication of genocide, they're just saying to the states that are warring or the state that is warring, stop doing what you're doing because you could cause irreparable harm while we decide on the merits. And so South Africa now is the third country to basically use this technique, to use the Genocide Convention, Article 9 of which, to bring Israel to the court and say to the court, we need provisional measures immediately to stop. That's one of the 9 requests that South Africa has made in its demand for provisional requests, that the fighting stop so that the court can ultimately reach the merits. And so South Africa is going to plead tomorrow. Israel will respond on Friday. I think what's interesting as an ICJ, I also teach public international law. As a court watcher, I think it's very interesting to see Israel is going to appear. It has hired a very prominent public international lawyer. And so the case is very much a high stakes case between very, very able legal teams. Obviously, it has a public dimension, an emotional dimension that we can talk about. But in terms of legally, that's the phase that they're in. In the Ukraine case, Russia did not appear. Russia declined to appear before the court. The court said, we're going to go ahead anyway. And within 3 weeks of Ukraine's application, the court had issued provisional measures. So there is a lot of pressure on the World Court now to basically do in the current case brought by South Africa what it did in the Ukraine case, which is issue a provisional measures order quite quickly without prejudice to a determination of the merits on the genocide claim itself.
And Leila, what do you mean by kind of quite quickly? That we know that the arc of justice is quite long.
It was 3 weeks.
3 weeks.
They did it in 3 weeks. The application was filed February 27th. The order in the Ukraine case was March 16th, which is lightning speed, right? In the international, things can take 10 years in international law. So the International Court of Justice acted quite quickly in that, a little less quickly in the Gambia case, but it was still quite quick. So the ICJ, I think, is under a certain degree of pressure to issue a judgment within a month, 2 months, not longer than that.
And that judgment is one on provisional measures
Just
and
on
not
the provisional measures.
On the merits. That could take many years to reach the merits of the case.
And it's not the only investigation that's ongoing. So the International Criminal Court is also looking into hostilities both on October 7th and afterward. But Israel is not a party to the Rome Statute. So how does this work?
So one of the things, just as I mentioned with the Rohingya case or the same with the Ukraine case, the ICC has jurisdiction if a state joins the ICC and crimes are committed on that state's territory, even if they're committed by the nationals of a non-state party. This is something that we can talk about later because the U.S. objected to this for a long time. It was one of the reasons the United States didn't join the court, because we wanted to have a veto over any cases involving our nationals. But the court, through a series of judgments and pretty much classical principles of criminal law. When I teach criminal law, if I stand in Canada and I shoot a gun across the border at somebody in the United States, I've committed a crime in Canada and in the United States. And that's basically the same principle that's happening at the ICC. So at the ICC, Palestine was able to join the court when the General Assembly voted Palestine membership as a non-member observer state. That's the technical term. It can't join the United Nations because the Security Council would have to approve that application, which the United States blocks. So Palestine was considered then able to join other international organizations, and it joined the ICC. Israel did not join the ICC. Palestine then asked the court to refer, and in the current case, 5 other states have also asked the prosecutor to investigate. South Africa, Brazil, Bolivia, Djibouti, and Comoros, maybe, I think, are the 5 that have also asked for the prosecutor to investigate. Now, again, an investigation is not a criminal case. An investigation means that the prosecutor is going to look at the evidence. The challenge here really is the prosecutor's been invited. He's actually been in Israel to talk to victims of the Hamas attack on October 7th, and he has stated that he will investigate that, which is interesting because Israel disputes the court's jurisdiction. So I'm not really sure how that will work, but at least right now, that's what the prosecutor has said. With respect to Gaza, he can't get access to the territory. So we have the same problems of how would you actually do an investigation if you have no access to the territory. He has been able to travel to the West Bank, but he's not able to enter Gaza. So right now, that's an open investigation by the ICC prosecutor. In the Ukraine case, it took about a year for the Putin arrest warrant to come out after Ukraine referred that case. So I think judging Karim Khan by his track record thus far, the soonest we would see something is probably a year, I think, in the Gaza situation. There's a lot of pressure on the prosecutor right now to do something, but the prosecutor's position is I can only do something if the law and the facts warrant it. I have to have a reasonable basis to not only open the investigation, but to go forward with a particular case. And I think he's going to be cautious because that's what we've seen. I'm not speaking, I don't work for the court anymore, but I'm not speaking for Karim, but we've seen that he's a fairly cautious prosecutor and he's not going to jump to do anything quickly.
And so, what do you do in this kind of situation where you don't have access to large parts of the territory where you're supposed to be investigating? How do you actually engage in an investigation? How does that impact the kind of findings you have? And to be honest, the accusation that really, justice has been there and the international justice has been wielded for the use of Ukraine. The US in particular has opened up its doors and, formed an atrocity prevention group and for Ukraine and not for what's happening in Israel and in Gaza.
Well, it's particularly challenging, but for the time being, the open source information coming out of Gaza and Israel is voluminous. So there's a lot of work there to be done just from open source information. You don't have to be on the ground in Gaza to do that. I remember in the early years when I visit the International Criminal Court in the early 2000s, I would see investigators at desks and I would ask them, what part of the world are they working on? And they'd say, part X, I can't get any access to it, but there sure is a lot for me to read first. And so there's a tremendous amount that can be absorbed from open source, as well as the prosecutor's own relationships and with various countries and their intelligence services. All of those come into play in terms of what his partnerships are, whether it be with the U.S. intelligence, British intelligence, Scandinavian intelligence, etc. All of those come into play in terms of how the prosecutor can at least do a tremendous amount of homework on a situation before getting on the ground. And also just in other situations, you have a large refugee population usually that you can start interviewing. This one is a little different because the Palestinians are not being permitted to leave Gaza. So there's not really a refugee population to interview yet. So that's a little crippling for the prosecutor.
And perhaps also less intelligence that you're necessarily going to get as well. And so maybe, one of the things that I want to maybe end on before we turn to questions from the audience is the situation in Ukraine and in Israel and in Gaza is devastating in many, many ways and is meriting of the enormous amount of attention that they're receiving. But they're not the only places where you have serious ongoing conflict in this moment. So in Sudan at the moment, the RSF is continuing to take over cities and the conflict is intensifying. in Ethiopia, while there has been a sort of ceasefire and peace agreement, there are no international justice mechanisms, and those, even the commissions of inquiry that have been set up have been blocked. In Armenia, you're not seeing kind of any movement. In the DRC, you've had elections that have just been contested. In the Central African Republic, you have enormous proxy conflict ongoing, and so on and so forth. How do we advance justice in contexts that are sort of quote unquote forgotten, that aren't capturing the kind of international media attention, or if so, only for a few moments, and where there isn't that deep investment of resources, money, experts to actually try to advance international justice?
Yeah, I'll just jump in first and say, you've just identified the enormous problem with international criminal justice. It's extremely labor intensive. It requires a fair amount of money, but comparatively speaking, not really that much money. If you want me to compare it to other endeavors of governments and of international organizations that far outstrip justice and accountability, but it does require that money. And the International Criminal Court cannot be everywhere doing everything intensively. For example, if it were to receive the Tigray situation in Ethiopia, that would require a massive staff and bureaucratic operation established within the ICC to investigate and prosecute the atrocities regarding Tigray. I will say this. I wish the U.S. government would take more of a lead in the Security Council. The Security Council referred Darfur back in 2005 to the ICC. It is there under mandate of the Security Council. Darfur has been reignited now with charges of genocide against the tribes in Darfur. The ICC has jurisdiction, and the prosecutor has made it a point to say, I have jurisdiction over what's happening in Darfur in 2023 and 2024. The U.S. could get the Security Council behind that and give the ICC the kind of momentum and resources to actually stand as a guardian of justice with respect to what is happening in Darfur. The ICC has that jurisdiction.
Yeah, and I might just add to that does raise the double standards issue, right? Because 2 years ago at the annual meeting of the court, when all the states were coming in and speaking about how important the court was, they all referenced Ukraine. And Darfur is a situation that has been there for a long time. The former president Omar al-Bashir was actually indicted by the court, and the Security Council just wouldn't back up the arrest warrants. And in fact, he traveled widely under indictment. States sort of thumbed their nose at the ICC, and he was able to make a mockery of the process in a way that I think had states stood more firmly committed to the institution and to those arrest warrants. He eventually, of course, ended up in jail because almost every one of these crimes, when you see these mass crimes, it's accompanied by financial crimes. And usually if it's a head of state, they've looted their own country. And so most of these individuals are actually brought down internally. Slobodan Milosevic ended up in jail in Serbia, not because of NATO or anybody else, but because they'd had enough of what he was doing there. And that's what happened to Omar al-Bashir. And we almost got him at the court, and then this whole other flare-up happened. But I do think that the lack of commitment is something that is very keenly felt in Africa, in much of Latin America. I think Venezuela is another situation where the court has jurisdiction, the court could be doing more, but we need state support, right? We need the international community to come on board. There's 17 situations on 4 continents right now at the ICC. It has a chief prosecutor, 2 deputy prosecutors, and 18 judges. So I looked it up before I came. Cook County has 400 judges for a population of 5 million people. So you just think of what resources are we really investing. If we want the ICC to work, we've got to invest the resources. And we're just not at that stage yet, because I think we're kind of we're crossing our fingers behind our backs and saying, well, we sort of want it to work, but not if it's my guy that's going to go to jail. And we just have to be consistent.
Yeah. And so I think on this note, I'll open it up for general questions from the audience. Either for those of you who are here in person, feel free to come up to the microphone. And for those who are online, I'll be monitoring the queue and asking those questions. And so first, maybe let's start with a question from those in person.
Hi, I'd like to know, does the ICC even look at the extrajudicial killings in Central America between El Salvador, Guatemala, Honduras? And could the ICC look into human trafficking of the migrants from Texas to Chicago and New York and LA or Denver?
Those are excellent questions. Do you want to take it, Layla, or do you want me to?
I can.
So actually, Layla, there's also a question online that's sort of related to the second piece, which is kind of what's the impact on the ICC given that the US is not a member, and how does that impact how it works? And so maybe I'll leave you the second part, David, as the person who signed the treaty on behalf of the US.
He's the long-suffering ambassador for war crimes that had to negotiate this as head of the U.S. delegation. So the ICC, the short answer to the excellent question is it has jurisdiction over virtually all those countries because almost all of Latin America is a party to the court. So extrajudicial killings in a country, and in fact, Honduras was in preliminary examination at the ICC for a long time. And the Inter-American Commission on Human Rights had actually called what was happening in Honduras with post-election violence. There had been a coup. They called it a crime against humanity. The ICC prosecutor decided not to go forward with that case. I won't say whether I thought that was the right decision or not. I was the special advisor on crimes against humanity at the time. I think the concern was that at the ICC, the thresholds have to be so high. Otherwise, the court is going to get completely deluged with everything. As I said, it's a relatively small court. And at least in Honduras, they had imprisoned about 3,000 people, which is quite significant. But there hadn't been the pattern of killings, torture, extrajudicial execution at that time that warranted going forward. That said, Venezuela is a situation, and the prosecutor has also made statements with respect to Bolivia, where there have been issues, and Colombia was for a very, very long time under preliminary examination. The ICC has no jurisdiction over crimes that could be considered ICC crimes that take place inside the United States of America because the U.S. has not joined the court. And Ambassador Schaffer will tell you why the U.S. has not joined the court.
And let me just, I do want to recognize, though, that you have with you here Layla Sadat. She's actually the pioneer who created the Crimes Against Humanity Convention, along with a large committee. But it was under her leadership beginning around 2007, rather? 2007?
It's a long time.
And it is now before the legal committee of the UN General Assembly, the sixth committee, where they're going to have one heck of a debate in October, right? And what we're hoping, and I know you are, Layla, is that the convention will emerge from this debate and then be on the market for ratification by countries around the world. Layla basically is the super author of that convention. So this is a very historic moment that you're actually seeing her because she's the real creator of the Crimes Against Humanity Convention. On the Rome Statute, I'm going to answer it sort of generally in the sense that I think the American difficulty with the Rome Statute has been that when we were negotiating it in the Clinton administration, and President Clinton wanted this court established, and he wanted the United States to become part of the court. That was his policy. Those were my directions. I worked under those instructions, not to kill the court, not to do something to undermine it, but to make it happen. And so that was the policy of the Clinton administration. And I signed the Rome Statute under his direction. But the problem is that I think within the American government, as well as within the American populace, there's too much of the mindset of being defensive about, well, how does this court threaten us, as opposed to how does this court give us a judicial tool to achieve justice and accountability and ultimately peace globally. In other words, how is this our tool? We talk in law circles of lawfare, and sometimes I think there's a misperception of lawfare. For us in the Clinton administration, this was one heck of lawfare. We were building something that would be projected internationally to stop genocide, to stop crimes against humanity, to stop war crimes through a judicial, over decades and generations, the implanting accountability for this. That's our lawfare. But instead, there was a mindset that developed, particularly, let's be honest, within the Defense Department of, well, wait a minute, can this possibly implicate a U.S. general someday in committing one of these crimes? When you go at something from that perspective, then you're lost, because of course there's always that threat, but we're a rule of law nation. If any of our top officials are to be implicated in any of these atrocity crimes, our own legal system should go after that issue first and foremost. And if it does, the ICC backs off completely. That's how we negotiated the ICC. If your domestic system finds someone who's committing genocide, war crimes, crimes against humanity, then you investigate. You prosecute, and you just show us that you did a good faith effort at doing so, that you weren't trying to manipulate the system. And then we, the ICC, back off. But that mindset has never quite left a good sector of the American government or the American people, although I must say, surveys by the Chicago Council on Global Affairs year after year after year show that a majority of Americans want the United States to be part of the International Criminal Court, to ratify the treaty. So that's the majority view by polling, but it hasn't taken hold yet completely. I will say that I think Ukraine opens the door, because the United States has seen the value of the International Criminal Court in holding particularly Russia to account for just egregious, not just aggression, but war crimes and crimes against humanity, and even charges of genocide. I mean, we could go for hours on that with respect to Russia. And the United States has recognized that and is now supporting the ICC with respect to that particular situation. That opens the door. The Republican senators that have always opposed the ICC walked straight through that door and said, yes, the ICC should be doing this and the United States should be behind it. That's the kind of proactive attitude that we were trying to get going in the 1990s, and maybe we'll get closer to it in the years ahead.
And so I have another question online about how does international law apply to war crimes to an organization like Hamas? And so maybe I can broaden that question and sort of say, is there obligations to non-state armed groups? And the question kind of asks about what happens if there's leaders of Hamas in Qatar and in Turkey. And so also a question about the kind of territorial element of those who may be accused of committing war crimes or crimes that fall under the jurisdiction of the court.
Well, so that's a really interesting question. So yes, the ICC applies to non-state actors. Non-state actors can commit all three crimes. They can't commit aggression, but they can commit crimes against humanity, genocide, and war crimes. And we have cases already that have been adjudicated, for example, where militia leaders in the Democratic Republic of the Congo or in Uganda have been indicted and convicted at the ICC. Because Palestine joined the International Criminal Court, Palestinian nationals are under the ICC's jurisdiction. And that's why what David said about the U.S., DOD being super scared, that the ICC, they're going to come for us. The ICC doesn't do that. It has no police force. They work through states. But most states see the ICC as a shield, right? They're trying to protect their territory. And when they join the court, they make a commitment that their nationals will not commit ICC crimes. So leaders of Hamas as Palestinian nationals even in an ICC non-state party, are nonetheless within the sort of jurisdiction, subject matter-wise, of the court. They may be beyond reach because those states, Qatar hasn't joined the court. So you can't demand cooperation from a state that isn't a party to the court. But the Palestinian Authority complies with the court. The Palestinian Authority says we support the ICC. That's why we joined the court. Israeli officials are not within, by their nationality, the ICC's jurisdiction. They would only be liable if they were committing crimes on the territory of an ICC state party. I think states should have, could I just add one note too? You know, the British were investigated for allegations of torture in Iraq. And the UK is an ICC state party. France is an ICC state party. All European countries have joined the court. And the prosecutor looked at that situation and said, the UK is doing its investigation. I relinquish my jurisdiction. I have no basis to prosecute. And I think that ought to give states like the United States some comfort that they're not going to be politically motivated. This was the prior prosecutor, Fatou Bensouda. So I just wanted to add that coda to what David said.
And also just to add the country of Colombia, which was under investigation by the ICC for many, many, many years. And so much occurred in Colombia with respect to the peace process, et cetera, and setting up new judicial instruments to bring the FARC to account and military forces to account, all within Colombia. And finally, the determination was made at the ICC to completely back off of Colombia because Colombia had stepped up to the plate.
We'll take one more question.
Hi. I apologize if my question is perhaps too basic, but my understanding is ethnic cleansing is not an independent crime under international law. And I'm wondering, is that because other aspects of international law can cover ethnic cleansing or different components of ethnic cleansing? Or if instead that we should make ethnic cleansing a separate crime, just given how heinous it is.
Do you want to take that, Leila?
Well, so that's exactly right. After the failure in Rwanda to protect the Rwandan people, a doctrine called the Responsibility to Protect doctrine was adopted by the United Nations. And ethnic cleansing was actually one of the categories of offenses listed in the Responsibility to Protect, that states had a duty to protect civilian populations from crimes against humanity, war crimes, and ethnic cleansing, as well as other offenses. But it's not actually a crime. It's not in a treaty. It's not anywhere. It can be a crime against humanity. So in the former Yugoslavia, the ethnic cleansing of Bosnia was essentially captured by the crime against humanity of persecution. That was the head of crime that the prosecutors used to bring those cases very successfully. In the Darfur situation, where the Janjaweed have gone out to attack these tribal, the Masalit and the Zaghewa tribes. That is a pattern of ethnic cleansing. The prosecutor charged it as both crimes against humanity and as genocide with respect to the former president of Sudan. There's some question as to whether he'll be able to show the genocidal intent in order to win that case. And there's been some conversation about whether the prosecutor might ultimately drop the genocide counts, preferring to go under the head of crimes against humanity. But I think, to answer your question, we can use crimes against humanity. It's an attack on a civilian population involving murder, deportation, displacement, etc. Those are crimes already within the Rome Statute. The difficulty we have when we add new crimes is they can be very hard to charge and prove. So it describes a phenomenon, but we already have, I think, crimes sufficient to prosecute if we're able to do so.
And sort of one final question, which I see online, and we have about just a couple of seconds each for you both to answer. And this is a really broad question, which is, do you think that the international community is doing all that it can to prevent future atrocities? And so maybe, David, I'll let you start, and then Leila to have the final word.
Well, no, it is not. But that's because of so many different factors. I would rather answer the question a little more positively by saying that we've come a long way in 30 years to recognize what is a violation of international criminal law, and to be focused on it, for civil society organizations to be so totally focused, as well as journalists. We know about these things almost instantly when they occur now, as opposed to the past when it sort of lingered. So we have the sensitivity of atrocities actually occurring, but we're woefully inadequate in physically confronting the atrocities and the forces of atrocities and actually stopping it, literally stopping it on the ground physically. We're getting pretty good in the judicial sphere of making sure that as they occur, there are mechanisms of investigation or justice and accountability that get ginned up very quickly, or maybe over a certain period of time, to actually address the issues. But in terms of physically confronting the atrocities and stopping them, we've got a very long way to go. And I'll just finish with this. Layla mentioned the responsibility to protect principle, which has not really achieved what it was intended to achieve when it was approved by the UN in 2005. I, as an international law professor, I just have to say, I still think there's a value to look back at the principle of humanitarian intervention and what it can achieve to save human lives, as opposed to being almost trapped by the gridlock of the Security Council, which will not approve the necessary military action to actually confront atrocities. Whereas under the principle of humanitarian intervention, all the way back to the 19th century, you could find a basis under international law to actually act.
So I might just add, and I think we have 30 seconds, the 1990s, we now know in retrospect, were this unbelievable era. The General Assembly called the 1990s the era of international law, the decade of international law, superpower cooperation. We had seen the fall of the Soviet Union. We didn't have the vetoes crossing each other constantly at the Security Council as we do today. We didn't have the Soviets vetoing and the Americans vetoing. Right now, unfortunately, we're in an age of rising authoritarianism, and we see Security Council dysfunction. And so I suppose we're not doing all we can do because we're in a different era, but that doesn't mean that we can stop dreaming or working towards doing better. We have done better before, we can do better in the future, but there's no doubt that right now this is a very discouraging period. It's a difficult period, but it's a period that humanity has lived through decades like this before, and hopefully we'll be able to do it and get out of this in a positive way in the future. And that's why we're working on a new treaty on crimes against humanity, because you can either sit and curse the dark or you can light a candle and say, we're just going to do better. So thank you so much.
And I think with that kind of call to action, we'll conclude our program. Thank you so much to the Chicago Council on Global Affairs for hosting us. Thank you to Ambassador Sheffer. Thank you to Professor Sadat. It's been a tremendous pleasure to have you. I think we've learned so much, and we're so grateful for your time. Thank you.